If you're a vibe coder, an employer, a founder trying to implement some of these AI systems into your workflow, this video is for you. My name is Lissette Eusebio. I am an attorney and tech founder, and I created this channel to break down the latest developments in AI and the law, and so that, we can try to understand what's going on, because there's so much happening all at once and there's just not enough legal guidance. Now, before I get into the case, I want to let you know I do use my AI digital twin from time to time. So if you see that, it's me. It's still me. I'm just busy dealing with life, but it's still me. Now, get into the case specifically. I want to talk about Kistler versus Eightfold today. And this case is going to be huge. And a lot of people in the tech and law industry right now are looking at it to see what the courts end up doing. And the reason why is because the implications are going to be massive. If you're out there as an organization or employer, a vibe coder, creating any sort of service that is scraping people's data from the internet, it doesn't matter if it's public data, that is profiling these individuals and then ranking them, you could potentially be exposed. You may be considered by the law to be a credit reporting agency right now, and you don't even know it. So it's really important for us to try and keep track of what is happening in this case so that we can protect ourselves proactively. Now, here's the breakdown. The plaintiffs, this is a class action, and the plaintiffs are arguing that Eightfold is in fact acting as a credit reporting agency because, in essence, they are doing the same thing that credit reporting agencies do. They're collecting information, profiling individuals, and then providing this sort of reports and decisions in terms of whether a person should be employed or not due to the likelihood of success. These are allegations. Obviously, Eightfold is denying these allegations. They are fighting back against this, and they're alleging that they're clearly not a credit reporting agency. They are not registered, so they shouldn't be held accountable to the same standards. In this particular case, we don't have any legislation that explicitly speak as to that particular issue, and we all are still waiting around to see what type of laws are going to come out with respect to liabilities for LLMs, which organization, who ends up being ultimately responsible for any of the things that the AIs are doing. And so because of that, we are going to see a lot of judges sort of come up with new laws. We call them cases of first impression, where we're going to have to use whatever we have to come up with some sort of rule that may be applicable. And what does that mean for you? That means that you should, in my opinion, be acting proactively so that you don't become the guinea pig, and the lesson for all of us. In terms of the potential exposure, if you're a builder, CEO, employer, anyone that's out here trying to use these systems to grow your business and to automate and do everything that you're trying to implement, as a tech founder and as an attorney, I think that the best way to deal with this is for you to take a proactive approach. What does that mean? It's going to be a little different for everybody. Immediately, I will say, first of all, understand that this is not legal advice. This is just general information that you can use to go and audit your workflows. But I believe that you should be talking to your attorneys, and you need to be getting some sort of guidelines, like what is it that I am potentially exposed to here? And if I was to be considered a credit reporting agency, what are the things that I need to be looking at, and what is it that I'm supposed to be providing? You need to have those conversations with your attorneys so that your attorneys can provide you some sort of guidelines that you can use and implement into your workflows. Speaking specifically to my coders, my engineers here, you're not just creating, a workflow. You are dealing with implementations of what is allowed and what will not be allowed, depending on where the law ends up here. So you want to make sure that the processes that you're putting in place are documented thoroughly, not just in terms of what the AI is supposed to be doing, but in terms of what is the guidance, what legal guidance did you input into this workflow, so that the AI can be making the decisions based on, what it is allowed to do. It's going to be extremely important for us to do that. You also want to make sure that you're taking measures to protect yourself when you're entering into contract with any other individuals or any of these vendors that are, creating this sort of services out here. We don't know how things are going to end, what the courts are going to end up doing. But what we do know is that every time we create a case, some sort of precedent, we turn around and then we use that same case to argue that other similarly situated individuals or organizations should be treated the same. So this is why the implications are so massive, because there is no statute on this yet. There's no regulation that can explicitly tell us, okay, this is what you're supposed to be doing. As always, I will be staying on top of this case, trying to see what the courts end up doing and what are the developments, and bringing you guys the latest on it. In the meantime, if you like this content and you're building or you're an employer trying to figure this out, you can subscribe, share this with any other people that are building and that can be benefited from using and listening to these updates. In the meantime, I will see you guys next time.